draft applications. And here that we can kind of go through our findings and talk about a little bit too. And both applications are actually real scenarios that happened somewhere, maybe here in Rollins. So anyway, we'll just kind of jump into this. So I've got on the first page the meeting procedure, which is pretty basic stuff. It's the same as council. We have that with quorum, which is 4 of our 7 members. We do have to have a majority vote to take any final action of any zoning variance or anything that's in front of you guys. And it is subject to open meetings act. So it is open to it has to be open to the public. We have to advertise our public hearings. So again, same rules as council. One of the things that I bring up the Open Meetings Act that has gotten some councils or zoning board of appeals in trouble for before is that oftentimes you guys will be looking at a specific site or property. And there's been in the past some, and this has even gone to court, things where council will meet at a property and they'll have a quorum. Well, you can't do that because again, it's subject to Open Meetings Act. So if you're going to go look at the site, you either need to do it by yourself, or if you're wanting to do it as a group, you would have a public notice that meet at the site and go through together so that you're all getting the same information. We have not done that at Blissfield because we're fairly small. So usually you guys just kind of drive by and see. Maggie does a really good job about providing maps and information for you guys. So we've not needed to do that, but I just wanted to bring that up.
In hindsight, that we should have done that, Daniel, is that a way to improve? I mean, and make sure that we're all on the same page. Do you think that's something that we should rethink and see it ourselves?
So I definitely
not necessarily.
I don't necessarily know that we need to have a published meeting on site. I would encourage you guys as individuals before the meeting, just drive by the property. Most everything that you need is going to be in your packet. Any zoning ordinances, any photos, but if you just drive by it enough to visually see it, I think that alone is sufficient to help you guys when you make a decision. If it's a larger project or something more in depth, then I would maybe say that would be beneficial. But most of the variances we get are like reducing a setback or increasing the height on a building.
Right.
We're not really getting crazy, bizarre things.
The only thing I would caution you with when doing a site visit, if you're going to do that, is to make sure that you don't get accidentally wrapped up and do like the situation where you may be biased. They talked about this quite extensively at Citizens Planner, where commissioners or council members would go do a site visit and then they would go and sit down and talk to the owners, and the owners would make them dinner, or you know what I mean. So that would be.
Well, and kind of further note, when I say you do a site visit or like drive by, and I'm not saying to have a conversation with the owner necessarily. I'm just saying drive by and just physically be like, okay, here's the property, and kind of visualize it. If you do have a conversation with the applicant, and I'm going to use you as an example, Glenn, let's say you do a site visit and the applicant's outside mowing, and you're like, hey, John Smith, I know you, and you talk to them and they say anything, then when you come to the public meeting, you actually should be sharing any conversation that took place so that the entire board then has that exact same information.
Okay. But ideally, if you're just do that drive by, take a look, and you just happy with that, then you have a decision. Okay.
So we already kind of touched on this, but conflicts of interest, it's again, this is very similar to council. You guys were supposed to declare them. Whenever a conflict is declared, it does under the zoning board, and it does have to actually be acted on by the rest of the board. So let's say Tim has a conflict of interest at whatever the item is, he would say, I have a conflict of interest because blah, blah, blah. And then the other 6 members would then have to consider that and vote. Once they voted and agreed that he had a conflict, then he would actually have to physically remove himself, or she, whoever it is, from the meeting, and would not be able to participate. And that actually means they're not even supposed to sit in the public, but that's a fine line, because then they can turn around and say, well, I'm here as the public member. Yeah. So I would how we've kind of handled it in the past is if they sit in the public, that's fine, but they cannot like contribute in your discussion as the board.
And I didn't realize that, so let's continue with Tim as that example. So Tim might say that I think I have a conflict of interest, and we would vote on that, whether or not we believe from our perspective, whether or not that would be a conflict or not.
Yes.
Regardless of what he said, we still would have to.
Yes, because let's say that Tim says, I think I have a conflict of interest because my brother is friends with this person, but Tim has no financial gain. There's nothing that benefits him if this application is approved or denied, but he wants to be forthcoming that his brother is friends with this applicant. Then you guys could say, we don't really care, Tim, thank you for letting us know, but you're not gaining anything from this. You're not the contractor on it. You're not, and we appreciate you making that known, but we're gonna vote that you don't have a conflict, and then he could still act on the application. So it's a way to kind of protect you guys if you're like, this is not really a conflict, but it could be perceived as a conflict, but because then you're kind of putting it to the whole board, like, do you guys agree with this or not? The board should not, if Tim says, I'm the contractor, I have financial gain if you approve or financial revenue or whatever, if this goes through and you guys vote no, like, we're probably going to be in a sticky situation if it's ever goes to court or is appealed. So in that case, like, it's a clear conflict of interest where you guys really, I mean, you could vote no, but I would not advise that. Our attorney for sure would not advise that. Okay.
He still wanted to contribute when he felt there wasn't a conflict of interest, but the rest of us did.
It would go to the rest of you. So that's the other thing. Let's say Tim says, I don't have a conflict. Who cares that my brother's best friends with this person? But the rest of you say that he does, that he's out. He can't participate.
Okay.
You're kidding.
No.
Wow.
Yeah, it is up to the whole board to decide that.
That's because he's living at Tim's house and Tim wants him out.
Well, and whatever the conflict. I mean, I gave a kind of silly example, but I just to, as I guess an idea. So I guess any questions on that?
Better to ask than not.
Right.
So I guess would probably be the better thing to think of it.
Yeah, that's,
So at least bring it to the forefront so that everybody knows.
because if you're thinking, somebody else is probably thinking, and like I said, sometimes it's maybe not a conflict, but it could be perceived. So it kind of, I think, puts it out there in the open, like, hey, this is a thing, and then just lets everybody kind of know where the rest of the board stands on it. So that I would agree with.
Is it conflict of interest? Only go with the zoning, or that's something that we do as trustees as well?
Well, it's,
I mean, I know that's not this.
yeah, so zoning enabling act specifically talks about conflict of interest and has the specific requirement of voting, but you could treat that the same as everywhere.
Okay.
And so we actually had this come up at planning commission a couple times. Like, we had a member that did not want to vote. And I think it was a subject that was a little bit split. So they were like, well, I have a conflict of interest. Well, they didn't have a conflict of interest. And when you guys serve on, whether it's planning or council, like, you do have, well, even recently, it wasn't conflict of interest, but we had somebody that were like, well, I'll just abstain. Well, you can't do that. Like, you guys are on a board, you have a right or responsibility that you're supposed to vote and act unless you truly cannot. So you can't be like, hey, what is the conflict of interest? But it is different than zoning enabling.
So they explained that, and everybody decided it wasn't a conflict.
Well, yeah, so the first scenario I gave you where it was kind of a split decision, they questioned, they're like, well, what's your conflict of interest? And he's like, well, I'm a business owner, and if this person comes in, it could make me, then somebody could stop by my store, and they're like, that's not really a conflict, like, you have a responsibility to vote, and he did end up voting. The other one, again, wasn't a conflict where they tried to abstain, but we just said like, you do have this responsibility that you can vote no, like, we're not saying it has to be a yes vote. If you don't feel like you have enough information or to make a decision, then say no, but you can't just not. So then conflicts of interest a little bit more specifically is a member or a member's relative or other family member is involved in the request. So if it's Tim's brother, that would be a conflict of interest. If the zoning board of appeals member has a business or financial interest in the property, involved with the request or has financial interest to the applicant's company or something, again, if I'm the contractor, I should not be voting, or if I partially own the property with Maddie and she's applying for a variance, and I'm on board, I should not be a part of it. If the zoning board member owns or has financial interest in neighboring property, so this is any property that would fall within the notification radius. So for zoning board of appeals, the notification radius is 300 feet. From the outside edge of the property. So whatever shape the property is, that outermost edge, out 300 feet in every direction. And then if there's a reasonable appearance of conflict is determined by the zoning board of appeals member declaring such conflict. And again, it cannot be used to avoid voting or things like that. Public hearing, I won't go into this too much because you guys pretty much got these. I'm happy to give some counsel too, but there has to be the motion to open the public hearing. We should be taking public comment from both sides for and against. The applicant gets the right to present, and then any against, they get the option to have some kind of rebuttal or response to them too, and this only for those meetings. And then once you go through that, you just motion to close the public hearing. Okay, findings of fact. So this is, yes, this is, I think, probably the area that I'm hoping to kind of focus the most on, especially with our samples and things. But so it is your responsibility to always cite your findings. And you should say why. Yes, because blah, blah, blah. Now, you can say just yes as an answer and nothing more. But the whole point of this is it actually because this is a statutory board. So you have legal requirements under state law and zoning enabling act that say you're going to meet all of these findings. And if they do not meet, even if it's one finding, then you shouldn't approve the variance. And once it goes through zoning board of appeals, it doesn't get appealed to council, it gets appealed to the court system, so local courts. So you've got to be able to then go back and say, why did we approve this?
Justifies.
Yes. And when you're going through these, I'm gonna say this. I'll regret it. You can make up any findings, any reason. And I say make up, like, I don't want you to truly make up a finding, but like, findings can be any creative reason or any reason that exists. There's nothing that says like a finding has to be within these parameters, is what I mean by making up a finding. So it's gotta be something that you guys can say and then justify or feel good, like, yes, the truth
It's
is
legal,
the case.
yes, like court system, right? It's how you interpret it.
Yes, yes. So, the other thing that I feel like you guys don't do and you can do is it is the burden of proof to meet these findings is on the applicant. So let's say you get to a finding, like I think one that you guys really struggle with specifically is is there something peculiar about the land that doesn't apply to other properties? So when you get to this, let's say you guys are really struggling with this finding and you're kind of talking about it, lean on that applicant. They have the burden to prove to you guys that they meet that requirement or not. And when they come in for an application, Maddie gives them an application and then she tells them, here's the findings, you have to meet these and it's your job it is your burden of proof. She explains all that to them, so they have it right from the get-go. And like I told her, like, I recommend be prepared to answer those. Have your reasons why you meet these requirements, because if you do, it's just gonna expedite and speed up your approval process because you've got it outlined for council. So you guys don't have to come up with this on your own. You can go to the applicant and be like, what is peculiar about your land? And if they say something crazy that you're like, no, that's not, that the 20 parcels around you are the exact same thing. Like, you can put it back on them and be like, that's not peculiar because again, there's 20 like parcels. So what is different about your property, or whatever the question may be. So I listed the sources of fact here, but I think the big thing, like, you guys, there's the application, you know about the ordinances, the heuristics of kind of what's around there, your staff reports. Again, Maddie does a really good job with her staff report. She puts the ordinances in there. She puts pictures of the property. She puts the buffer map in there. She puts a copy of the buffer letter. Anything like that, any site plans that they attach for you guys, she includes all of that in her plan.